mother sees it with her sleeping eyes, and I know that when she said she's gonna try, well, it might not work because of other.
Good, everybody.
I know she usually has some other ties, and I wouldn't want to break.
When did it stop? It should stop. It's bad.
Maybe she'll help me to untie this. Until then, well,
I'm playing Flake by Jack Johnson, in case you're wondering. All right. Okay, so legal analysis scope. The opinion that just came down today in the case Department of Commerce versus New York. This is the census question, whether or not that the Department of Commerce and Wilbur Ross, in his wisdom, could include a question on the census that would inquire whether or not respondents are citizens. For background, this is a question that was on the census for most of the United States history until 2000, as far as I can read from the facts here. That was removed when they were trying to streamline the census, but the administration wanted to add it back in for its reasons. The case was challenged on on grounds that it was arbitrary and capricious. So to kind of understand, I'll do a little bit of explanation. I'm not a huge expert in administrative law, but we'll give sort of a basic rundown of the stuff that's relevant to this case. So the key phrase again is arbitrary and capricious. So let's get on. Basically, the arbitrary and capricious standard is very deferential. So what happened here is there's an agency decision, right? The decision to re-add this to the census was a decision made by Wilbur Ross at Commerce. There is a standard way of reviewing an agency decision for whether or not it's lawful. And one of those standards is what's called arbitrary and capricious review. The idea being that agencies can't just take decisions randomly for no reason. That's basically what it's trying to prevent, or to have really bad faith. So that's essentially what it is. So as Justice Thomas explains in his partial partial dissent, he says it requires the reviewing court to determine whether the agency examined the relevant data and articulated a satisfactory explanation for its action, citing the Supreme Court case FCC versus Fox television stations. Quoting Thomas again, we have described this as a narrow standard of review under which the reviewing court cannot substitute its judgment for that of the agency and should uphold a decision of less than ideal clarity if the agency's path may reasonably be discerned. So the idea here is that unless things have gone really wacko, really crazy, you generally don't overturn decisions on arbitrary and capricious grounds. What happened here? Well, John Roberts, in his wisdom, split the baby. The split in this case is bewildering in terms of how the justices came down. So to understand, sometimes justices will join parts of an opinion, but not other parts, right? So they'll say, well, I agree with you on the part 1 and 2 about standing, but I don't agree with you about these other questions later on. So that happened in this case. And John Roberts really did split the baby. So understand, what was Roberts' opinion? He said, quote, 1, the decision to add a question to the census was not arbitrary and capricious because there was sound reasoning to justify wanting to get better immigration data. That's a reasonable thing to do. It's not incoherent or nonsensical. That in order to get better immigration data, better data about who is a citizen in this country, it is perfectly reasonable to add a question to the census to that effect. It's really kind of ridiculous when you think, how can you argue the contrary? That literally that the United States government has no possible reason for wanting to know who is a citizen. Think about what it means to say that that would be arbitrary and capricious. That was part 1 of Roberts. And with that, all the conservatives agree with him. So we had, for that particular part of the opinion, there was, Alito, Kavanaugh, Gorsuch, who's the other one? Thomas, all agreed with him. Part 5 of the opinion is not good. Part 5 says, but we don't think that the stated reasoning of Wilbur Ross and the Commerce Department is the actual reason they decided to enact this. We believe their reasoning was pretextual. And because it was pretextual, has been a strong showing that it was made in bad faith, and thus it must be overturned, and the Department of Commerce must make a new showing. It's literally the argument. You might say, Will, that sounds a little exploitable. That maybe if you can figure out that somebody's reasoning was pretextual, that sounds a little exploitable, a little easy to get agency decisions overturned. Yeah, that's sort of Thomas's problem in the dissent. I read Thomas's opinion, and I've read the majority. I think Thomas has it completely right. This is a very, very novel approach to administrative law, to say that they can inquire into pretextual decisions. And in a lot of other areas of law, pretext is scorned as a way to overturn something. So, kind of an analog, not super applicable to administrative law, but it's a similar mental problem, or a similar problem. So, in many cases, there are arguments that searches that are pretextual should violate the Fourth Amendment. Many people have argued this, right? So say a police officer pulls you over because you have a bad brake light, but in reality, you think there's evidence that he was motivated by, say, racial animus or something else. The Supreme Court has held that you can't say that it was an illegal search as long as there was a lawful reason. So if a guy says, look, it is a violation of the law to have a broken taillight, and so I pulled him over to do a basic stop, I stopped the car and to talk to them. Oh, and then I smelled drugs or whatever. Pretextual stops are fine, right? They're totally lawful. And the idea that you can, even if the actual intent of the officer was, I think this guy's got drugs in his car, I want to have an excuse to search him, it doesn't matter. As long as they have a reason that is lawful, they can do it. So pretext is generally frowned upon in a lot of areas of law, and it should generally be frowned upon here. But here's the thing to understand. So to kind of explain the factual details of what went on here and why the court thought it could get away with this pretext argument. The rationale that Wilbur Ross used and this Commerce Department used in order to justify why it was lawful and reasonable to reinstate the citizenship question, they relied on essentially giving the DOJ better citizenship data so that it could help the DOJ better enforce the Voting Rights Act. Now, the Voting Rights Act has a provision that deals with whether or not protected minorities, I think is the actual legal phrase, protected minorities are being oppressed by particular gerrymandering, voting districts, etc. Right? We had a different political gerrymandering case that was thrown out today, but in general, racial gerrymandering, there's sort of an issue there, and the Voting Rights Act was written to protect against racial gerrymandering. But the argument is to figure out whether or not this gerrymandering is actually inflicting a harm on protected minorities, you actually have to have an idea of how many people are able to vote, how many people are lawfully able to. And so in that respect, basically the thesis of the Commerce Department and the DOJ was that it is perfectly reasonable for us to ask for citizenship data in order to be able to accurately enforce the Voting Rights Act. Because if we're going to enforce this rule about making sure that minorities aren't oppressed, that they aren't gerrymandered into single-member districts where the vote can never have any meaningful impact, we need to know who's actually capable of voting, right? That's a prerequisite to making a meaningful analysis of that. The problem, from the court's perspective, is that they believe that rationale was pretextual. Now, in sort of the abstract sense, of course it was pretextual, right? Obviously that was not, when people were talking about the citizenship question, that was not the initial reason, that was not the initial thing they thought of as a reason to do this. Clearly, Wilbur Ross, there's plenty of evidence suggesting that both Wilbur Ross and President Trump wanted a citizenship question on the census from the moment that they took office. That's obvious. But that's not the standard, right? Just because you had other motives for taking an administrative action, that's not a basis on which a court is supposed to overrule you. That's not a basis. And even Roberts and the rest of them concede that that's not supposed to be a basis, that there are other reasons. The question is, one, was it reasonable? Was it a reasonable thing to do? Your stated rationale, was it reasonable? Was it an arbitrary, capricious reason that made no sense? Or was it a reasonable thing based on evidence? And the court, including Roberts, found, of course, it was reasonable. Perfectly reasonable to say, in order to enforce the Voting Rights Act, obviously it's useful to have citizenship data. But the second step, basically, Roberts joined the liberals. Flaky John Roberts joined the liberals in order to hold, that this rationale, the Voting Rights Act rationale, was pretextual, that it was made in bad faith, that it was not the reason that ultimately Wilbur Ross and President Trump wanted to institute a citizenship question. The problem, it's not how you evaluate it. As we'll go to Thomas's dissent so I can explain like exactly what's wrong with this reasoning, because I think Thomas is exactly right, and I don't feel like the majority opinion addresses this at all. Right? It's one of these cases where the majority opinion doesn't even bother to deal with the arguments in the dissent, which seem really compelling to me. And it's real. This is always an obnoxious complaint about someone who's, when I was in law school and still now, when the majority opinion doesn't address the arguments in a dissent, it is consistently obnoxious. So, right. He says, this is his characterization of the majority opinion. This is Thomas. Acknowledging that no particular step in the proceedings here stands out as inappropriate or defective, even after reviewing all the evidence in the record, the court nevertheless agrees with the district court that the Secretary's rationale for reinstating the citizenship question was pretextual. That is, that the real reason for his decision was something other than the sole reason he put forward in his memorandum, namely enhancement of the Department of Justice's Voting Rights Act enforcement efforts. According to the court, something just, quote, seems wrong, end quote. This conclusion is extraordinary. The court engages in an unauthorized inquiry into evidence not properly before us to reach an unsupported conclusion. Moreover, each step of the inquiry offends the presumption of regularity we owe the executive. Namely, the presumption of regularity is the idea that, if there's not clear evidence of bad faith, you assume good faith on the part of executive branch officials who have taken an oath to uphold and support the Constitution of the United States. So, some things from, Thomas's opinion that are explaining why this is so bad. Quote, unsurprisingly, this court has never held an agency opinion arbitrary and capricious on the ground that its supporting rationale was, quote, pretextual. Nor has it previously suggested that this was even a possibility. Under, quote, settled propositions, end quote, of administrative law, pretext is virtually never an appropriate or relevant inquiry for a reviewing court to undertake. Respondents conceptualize pretext as a subset of arbitrary and capricious review. It is far from clear that they are correct. But even if they were, an agency action is not arbitrary or capricious merely because the decision maker has other unstated reasons for the decision. Nor is an agency action arbitrary and capricious merely because the decision maker was inclined to accomplish it before confirming that the law and facts supported that inclination. Accordingly, even under respondents' approach, a showing of pretext could render agency action arbitrary and capricious only in the infinitesimally small number of cases in which the administrative record establishes that an agency's stated rationale did not factor at all into a decision, thereby depriving the action of an adequate supporting rationale. So, what is he saying? He's saying, even if pretext could be a basis on which to say that an agency action was arbitrary and capricious, the only circumstance where that could be true is if the record shows that the agency's stated reasoning for taking the challenged action, the stated reasoning had nothing to do with it at all. Like, not even that it was part of it. Not even that it was a minor, a small part of it, a minor rationale. You have to show that it was not at all. They didn't care at all about it. And Thomas's point is, you didn't do that. You've shown that, yes, clearly, it's obvious that there were other reasons to want to implement a census question. But other reasons is not enough. You need to show that their rationale, the reason, the Voting Rights Act reason, had nothing to do with it at all. Zero. Absolutely nothing. And that's probably not true, because both DOJ requested it. 5 DOJ lawyers reviewed it, said this was a reasonable thing for the Department of Justice to request this data. And then Commerce acceded to this request. So many layers of both lawyers at the Commerce Department and at the Department of Justice agreed that this was a reasonable thing to do, that it would assist in the enforcement of the Voting Rights Act. Like, even if that's not the primary rationale, that's part of it. And how do you know it's not? Hoya asks a very good question. Could this novel Roberts standard for judicial review set a harmful precedent for other cases? Indeed it could, because guess what? It's not hard to challenge agency actions as pretextual, because agencies routinely change their opinion on the law when a new administration takes power. That's very, very common. For example, net neutrality is a really good example of what happened. Before Obama, net neutrality was found by the FTC to be not an accurate way to, not within their authority to implement. But in 2016, the FCC changed its opinion of the interpretation of the underlying statutes and changed its opinion and said that net neutrality was actually mandated. Under this standard, that could be challenged as pretextual, right? Whatever reasons the agency came up with, you can probably figure out that Obama wanted net neutrality for reasons independent of this changing interpretation. He wanted it for his own personal political reasons to support his donors, perhaps. That's a problem for an executive branch. This is actually, in many ways, this is actually a significant usurpation of power by the judiciary from the executive. Like this decision is like actually constitutionally problematic. It's a pretty clear usurpation of power and an extension and really quite scary in that respect, because it's not, it's really creating a Trump exception. Now, Republicans could exploit this in the future, right? If this is going to be the rule, then like watch a Republican Supreme Court start overturning agency actions from the left on the grounds that they're pretextual. Although, I don't know, I mean, we actually have to get a few more Supreme Court justices to do it. But if pretext is the rule now, guess what, boys? Like, you want to change regulations? Well, courts are going to say no. Somebody says, quote, how is putting a citizenship question judicially reviewable, but gerrymandering is political? The answer to that question is that the census decision, that's a decision made by an agency. Agency decisions are generally reviewable under this arbitrary and capricious standard, according to the Administrative Procedure Act, the APA. The APA governs basically all executive agencies. And it sets the framework for how those agency actions and decisions can be challenged in court. So, when the EPA makes a decision, it's governed by the Administrative Procedure Act. When, alcohol, tobacco, and firearms makes a decision, tries to make a new rule, say on bump stocks or something, the Administrative Procedure Act governs how those things are interpreted. So, so the answer to the question about gerrymandering is that gerrymandering, especially on a state-by-state level, that's not a federal administrative act, right? Because that's like the state of North Carolina making a decision about how to allocate representatives in North Carolina, or the state of Florida doing it. So it's, one, the APA doesn't come into play, and two, that's more squarely in the political question grounds, because that determination is really a political question determined by the representatives, and not something that has like constitutional basis. It's a political dispute. It's not really, Christian says, a separation of powers. It's not really a separation of powers question, because if there were a constitutional issue with state gerrymandering, which is one of the arguments, then it would still be a case in which the Supreme Court could say something. But saying it's a political question means it's something the court shouldn't resolve in general. That's what happened here. Roberts split the baby. He's like, sure, it's perfectly reasonable and is not arbitrary and capricious to add a citizenship question to the census for the purposes of helping to enforce the Voting Rights Act. But because we don't think that's the real reason, we're going to reverse you anyway. It's pretty wild, actually. It's a very aggressive thing. So I'm pretty disappointed. Shockingly, John Roberts really doesn't like the President of the United States. I think that's been obvious, given that he chastised the President previously. Not surprising that that's the case, but disappointing nonetheless. So he says, why send it back, not uphold? They sent it back because basically it's like, because the argument, there needs to be a deeper finding on pretext. Yeah, Trump won't ban silencers, though. His son won't let him. Yeah, John Roberts, not a fan. Not a fan of John Roberts, frankly. He's got like the worst kind of lib tendencies. Apportionment? I don't know about what apportionment or how that's referenced in here. What is the next step? We're going back to the district court, coming up with maybe a new reasoning, new rationale, new attempt to justify the census question before like October, when they need to take it. Should be challenging. It's not over on this, but it certainly is a setback, and it's a setback that is based on a very, very bad Supreme Court opinion that I think is pretty ridiculous, frankly. But this is why we want conservative judges. Because, of course, the liberals are lockstep on every liberal policy preference, right? Like, that's, of course, the four liberal justices will just agree on everything in this case. Like, oh, you mean, like, Orange Man bad and doing something bad? Well, in that case, clearly, it's what he's doing is unlawful. It's the Trump thesis, right? Deference to the executive branch, deference to agency actions, deference to the president, reasonable, presumption of regularity, all that goes out the window of the Trump administration. It's like a unique set of laws because they don't think President Trump is any good. Right? Like, Roberts is such a judicial modesty guy, such a deference guy when it came to the Obama administration, but now it's Trump. It's like, actually, let's look behind the curtain here. Yeah, it's not good. Not good. That said, the Trump administration could have done a lot better, I guess, in terms of being a little more pristine in terms of the way they presented the administrative record, but that doesn't mean that there's any good reason for what the court did today, and Justice Thomas' opinions is right. Somebody says, apportionment is a key question here. How can we fairly apportion if we don't know citizen count? Well, I mean, that might be true, but that's not the reasoning, ultimately, that whatever his name is, Secretary of Commerce, Wilbur Ross, it's not the reasoning he relied on at all. A few more questions. Can it be reversed in time for census? I think so. People are saying that, but it'll be challenging. And it may not be reversed by the Supreme Court. It may just be that the Department of Commerce has to kind of come up with a new rationalization, because we already have seen that, like, these things, this is justifiable. What about the pretext of Obamacare not being a tax? Right. I mean, different set of legal principles there. That is more a question of whether or not the legislation itself, Obamacare, and particularly the individual mandate, was constitutional, right? So this is an Administrative Procedure Act question. That's a constitutional question. You know, Administrative Procedure Act, statute, Commerce Clause, Constitution. And that's a question of whether or not the attempt to mandate that commerce come to existence was lawful, and that was found to be unlawful by Roberts. He said that was actually, that's stretching the Commerce Clause too far. Just because you have the ability to regulate commerce does not mean that you have the ability to mandate its existence, essentially by forcing people to buy health insurance. But the decision there was that the penalty that they were using was really equivalent to a tax. That decision, honestly, as a legal matter, I don't think is terrible. Actually, I'm not sure that's even wrong as a legal matter. Like, it was a real stretch to say that the individual mandate was unconstitutional. Think about that. That's a hard thing to say, right? The government has the combination of the taxing power and the commerce power. Those are big powers. People forget that. Like, those are constitutional abilities that the Congress has. The authority to tax and the authority to regulate interstate commerce. Like, to try and read those in such a cramped way that you couldn't do something like the individual mandate was always going to be a challenge. And it's sort of, like, the real answer there was we shouldn't pass laws like that because they're a bad idea, not because they're necessarily unconstitutional. Somebody says, Roberts rewrote the legislation from the bench to uphold Obamacare. See, I mean, that's where I actually, like, people get after him for this. I can argue this one for a while. I don't think he rewrote it, because, like, his argument, is it a penalty or is it a tax? Like, what's the difference between the two of those things? Could it be understood as a tax? Like, that's a more reasonable decision than this one, honestly. Roberts' decision on Obamacare was better than this one, which is bad. Just bad. Like, I'm sorry. You don't get to look into pretext. This is ridiculous. We've never done that before. Remember, again, like in this case, Roberts is saying something's unlawful. Stretching to find something unlawful. That's not judicial modesty. In that case, like the other case, Roberts was stretching to find an act of Congress lawful. That's not, like, maybe he's stretching, but I don't know. That's a close question. Closer question than people realize. But he's flaky as hell. Anyway. Ricky's got it there, humanevents.com/members. Gabe Malore, I would read other lawyers on the actual process and how it will go from here, because that's not my area of expertise, really. Like, I'm pretty good, when it comes to me being a lawyer, like, again, I didn't practice that long, but what I'm pretty good at is sort of the analysis, right? I'm good at the side of this that's like, what are the legal arguments? What's the legal theory? What is the basic template for how to understand, what's the basic theory? What's the doctrine? And then whether or not it's being properly applied. I'm good at that, not so good at, like, I don't have so much experience in understanding the actual mechanics of litigation and understanding the timing of things, so that's not where my area of expertise is. But I think we'll be able to do it. Anyway. Yeah. All right, that's what I got for you. Thank you so much for watching. Hope you enjoyed it. There will be more on this. Follow, if you're new here, ... in the bottom right-hand corner of the screen. The follow button gets you access to my fire hot takes and my legal analysis whenever it comes out. And follow me on Twitter @WillChamberlain. And read Human Events, and become a member, www.humanevents.com/members. Peace, guys.